everybody. Thanks so much for coming. I'm Zachary Stone, and I'm the president of the Plan 2 Debate Organization. The Plan 2 Debate Organization seeks to host public debates with advocacy groups anywhere on the political spectrum, and we're really excited for our first event tonight. While I am going to kick off our first debate, we want to enable students who have the ability and desire to defend their views to do so against advocacy groups that think otherwise. From that process, we all learn a lot about the subjects in question. A couple of months ago, I don't think I actually thought we'd be here tonight to have a debate against the National Rifle Association. And I'd really like to thank them, particularly Mrs. Anglewicz, for coming out tonight from her national office for this educational event, free of any speaking fees. Suzanne Anglewicz is the NRA's manager of political and legislative activities, working in the association's lobbying arm, the Institute for Legislative Activities, Action. I would also like to personally thank Dr. Joel Rollins for helping me run and start this organization. Plan 2 sponsorship with the promotions is also very much appreciated. Today we're going to talk about the extent to which the Second Amendment affords an individual right to keep and bear arms in modern America. While we tend to hear debates that focus more on facts and figures in the media, the constitutionality debate came to the forefront of American gun legislation after the Supreme Court used it as a basis to overturn a long-standing handgun ban in the 2008 case of Washington, D.C. versus Heller. Before any laws passed during this national call for new gun legislation, constitutionality must be considered. It would be counterproductive for both sides to pass a law that got shot down by the Supreme Court just a year or two later. I chose this topic to contest some of the assertions coming from the gun lobby that claim a great deal of support and inspiration from the Second Amendment, and then end the argument there. The debate will follow the format on the screen. Afterward, we will take about an hour of questions from the audience, and while we will take those spontaneously, if you come up with one during the debate, try to note it so that you can reference a certain point. We really do want to encourage participation in the questions, and follow-ups and engagement will be allowed. I want to make it abundantly clear before we begin that I do not support categorical bans on firearms or any other law that would unreasonably limit an American citizen's ability to protect himself or herself. I support a right for individuals to reasonably prepare to defend themselves. I simply do not find evidence of this right anywhere in the Constitution, and I actually find that problematic. So, without any further ado, we'll begin with the first speech. The Pew Research Center published a poll from February of this year showing that a fringe minority of gun owners, 2%, own guns to exercise a Second Amendment right. Yet the National Rifle Association maintains the myth that they exist to popularly protect Americans' Second Amendment rights. The version of the Second Amendment promoted by the NRA is out of touch with text, history, and precedent. The NRA holds that the Second Amendment protects our right to self-defense and arms the people against the government and invasion. This interpretation contradicts itself, but leads to dangerous chest thumping in which many feel almost a divine inspiration from their mythical Second Amendment. When we look at what the amendment sets out to protect, most Americans find it increasingly out of touch with them. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So reads the Second Amendment of our Constitution. The NRA would have you believe that the first part of this amendment, the prefatory clause, does not impact modern lawmaking in any way. As Chief Justice John Marshall stated in his decision in Marbury v. Madison, it cannot be presumed that any clause in the Constitution is intended to be without effect. In 2008, the Supreme Court ruled in Washington, D.C. versus Heller on a 5-4 decision that overturned more than 200 years of precedent. By claiming that a handgun ban was unconstitutional because it infringed on self-defense capabilities, the High Court chose to deny any lawmaking implications of the first part of the Second Amendment. The NRA's interpretation violates the constitutional tenet of originalism. The Second Amendment was formed out of revolution to prevent tyranny, protect against invasion, and possibly quash slave rebellions. The concerns of the militia have no bearing on firearm regulations. The concerns of public safety and self-defense, nowhere stated in the Constitution, dominate the national debate. The NRA certainly does assert, albeit not exclusively, that it supports the right of the people to keep and bear arms in order to organize an effective militia. Americans who are militia proponents tend to also be NRA members. Lawmaking realities as well as technological advances have destroyed the possibility of an effective militia. At this point in time, even the strictest of scrutiny would find compelling demands for public safety at odds with the militia. The contradiction in the NRA's stance is seen when asking why we cannot own machine guns, tanks, or nuclear weapons. Given our standing army, the media and mass communication, and a more representative political system, most Americans think that the need for a militia is likely obsolete, but this myth is exclusively what the Second Amendment protects. Most people who own guns do so for self-defense and hunting and sport, which are not presently protected by the Constitution. If one more liberal justice takes to the Supreme Court, firearm bans that really cut into self-defense capabilities will likely be allowed, like the one that existed for 32 years in Washington, D.C. Gun rights activists do not want this. Gun regulation advocates don't like the ambiguity present in our current system. Justice Breyer, frustrated, asked in his 2008 dissent, how is a court to determine whether a particular firearm regulation is consistent with the Second Amendment? What kind of constitutional standards should the court use? How high a protective hurdle does the amendment erect? Gun regulation advocates see it only legally prudent to incorporate militias into our standard, which feels ridiculous and embarrassing, whereas gun rights activists seek to place a right of self-defense somewhere in the Constitution, something that will not consistently be seen by the nation's constitutional arbiters. Americans own guns for self-defense and for hunting and sport. A right that protects self-defense also protects access to hunting firearms. With so few Americans owning guns for militia, and so many Americans owning guns for self-defense and hunting and sport, why do we not amend the Second Amendment so that it protects the right to weapons for self-defense, balanced only against compelling concerns regarding public safety? Once we formally characterize gun laws as a question of self-defense and public safety, gun laws become a legitimate public policy question informed by expert testimony, industry interest, and public opinion. The question of whether an M10 hurts more people than it protects is not a question of rights, but rather a question of evidence. That evidence for either side has little significance under our present and impertinent constitutional interpretation. Questions regarding background checks and magazine sizes formally concern an anachronistic right and a mythical freedom, that to a militia, but really concern a right to self-defense and public safety. These questions have answers in evidence, and our current system is not set up to legitimately hear that.
Question? Is there any question?
Yes.
Can you define what an M10 is?
My understanding is that an M10 is a form of a semi-automatic.
Can we just okay, no, I'm sorry, we can do it. What is an M10?
My understanding is that an M10 is a form of a semi-automatic assault rifle.
Okay, and what is an assault rifle?
Well, the official definition of that is contested, but my understanding...
It's not actually under the federal definition, under the law it's not, so there is a strict definition. Do you know what an assault weapon is?
I suppose I don't know the explicit federal definition.
I'm curious what your definition of militia is.
My understanding of a militia is that you have a paramilitary organization that is arming itself to protect against government tyranny and against foreign invasion.
And where is that definition from?
I could certainly pull one up, but I believe that's the traditional understanding.
How about the Supreme Court? What does the Supreme Court define militia as?
The Supreme Court then defines the militia in the context of 1776, something that rebelled against the government into saying, first, there wasn't the army, there was the militia.
I will give the definition of militia from the Supreme Court shortly. What is the definition of arms?
That is also certainly contested, but if we're going to say firearms, then perhaps we restrict that. But the definition of arms in the Second Amendment and in the linguistic history of the time was used to mean a military form of weaponry.
Okay, I have no more questions, so can I just get into my assault gun? Okay.
Sure.
So each of these definitions are very defined throughout history, and I'm going to tell you what each of those means, not just through any type of interpretation. I want to start very importantly that the Bill of Rights and the Second Amendment are not mere suggestions on parchment paper. You can't just decide that you want to edit and delete and retract certain things because of a political motivation. That's not how our country was set up. The debate that we're doing today is very interesting, and it's a fantastic debate for you all about collective rights, meaning the Second Amendment isn't an individual right, or is it a right that belongs to the government or what he's called a militia, which I'll define for you. This particular debate has been wholly manufactured, and it's a short-lived debate that's currently dead in all of legal academia. It's based on political motivation. It's not rooted anywhere in any type of constitutional theory or even in academic legitimacy. I cannot change anybody's mind who's looking for a different definition of the Second Amendment based on their emotions about the current gun control debate. Those are two entirely separate debates about the Constitution and about gun control. Because a lot of people base their idea of the Second Amendment on emotion or on their lack of understanding of the modern gun control debate. But what you can't change, I can't change anyone's mind on what they wish the Second Amendment said. But what you cannot change is the facts and the overwhelming evidence. The facts are the facts. No matter what happens, the facts will not change, and that's what I'm going to tell you about tonight. The Second Amendment is an individual right. This has never, ever been the made-up view of the National Rifle Association. When I say the evidence is clear, I could read you the Founding Fathers' papers, I could read you Federalist papers, of which I hope all of you will read sometime in your academic career. The Founding Fathers' intent is so very clear. The proper historical context, it's difficult to understand, but again, largely accepted these days. The fundamental principles of how constitutional theory works, again, you don't have to be a constitutional scholar to understand the easiness of what a right and a power is. Our U.S. Congress has multiple times from the 1800s declared the Second Amendment an individual right, irregardless of your membership in any type of militia. But the fact that the legal academy has entirely rejected this view, and again, they not only rejected, they've orphaned the argument because there has been such a torrential backlash in scholarship against any type of collective rights theory. But the death blow to this whole theory about a militia and so forth is really the U.S. Supreme Court in Heller. Not only in 2008 did the Supreme Court say you have an individual pre-existing fundamental right as an American citizen to keep and bear arms. Again, in 2010, McDonald did the same, but they even made it stronger, saying not only do you have a right to keep and bear arms at a federal level, but you do as a state citizen as well. Just to be very clear, the decision, as he mentioned, was a 5-4 decision. Not a single dissenting justice, not a single dissension, actually adopted the view of the collective rights theory. So again, it's sort of a death knell for the collective rights theory. Again, you don't have to be a constitutional scholar to understand two very simple concepts. Rights belong to people and powers belong to government. That's the bottom line. When you start learning about the Constitution, when you see the term right, that's why the Bill of Rights is framed differently than the rest of the Constitution. Because those first 10 are about your right as an individual. We certainly don't have this debate about the First Amendment, the Fourth Amendment, the Fifth Amendment, but we certainly do about the Second. So again, the term arms means bearable arms. Arms does not mean nuclear weapons or tanks or weapons of mass destruction. Very, very, very clear in scholarship that arms means bearable arms. Second, the term militia, just so you know, and I actually, just so I wouldn't get it wrong, is that the mutual understanding, again, across legal scholarship is that a militia is the whole people with the ability to take up personal arms. So I just want to wrap up that the Second Amendment was not written in disappearing ink. To suggest that we should change the Second Amendment with no practical explanation as to why, how it would work may be convenient in response to a political wish, but it's unfortunate to focus a very important debate of which he alluded to about background checks and mental illness and those types. It's unfortunate to focus on undermining the Constitution when what we should be debating is how do we keep us safe? How do we keep guns out of the hands of the wrong people? Not undermining the Bill of Rights and our U.S. Constitution.
Questions? Why did the Founding Fathers put the Second Amendment into the Constitution?
Well, they did so because as the United States is an infant compared to the rest of the world, and nowhere else in history or any other country do you have the right to take up arms for the common defense, and that's exactly what it was about, as he mentioned. Now, the right to self-defense has nothing to do with the Second Amendment. That's a human right. So when he alluded to hunting and self-defense, that is not what the Second Amendment is about. The Second Amendment is about taking up arms for the common defense, which is why the militia meant the whole body, meant anybody with their guns. The reason the founders put that in there was specifically because if you look at how our founding country was founded, it was by taking up your own personal arms to fend off the strongest tyrannical country in the world to get our freedom. So you can't compare the U.S. to any other country because we put it in there specifically for that fact, for bearable arms specifically.
So would you agree that most NRA supporters, most gun rights activists around the country who feel a connection with the Second Amendment do so because they think that it also provides them a certain protection to self-defense, a certain protection to raise arms to defend themselves, not from the government, but from a burglar? Right,
absolutely. And that's the point, is that you have a right to keep and bear arms for defense against tyranny, for common defense, which is a pretty broad term, and that's what the Supreme Court defined it as a common defense, at home, so forth. So Therefore, yes, you use a firearm to hunt, you use a firearm for self-defense, but again, it has nothing to do with hunting and that sort of thing. But yes, you're right. I'm not sure what you're getting at.
The NRA seems to have a very strong interest in the Second Amendment when only 2% of Americans own guns to prevent against tyranny, whereas many Americans own guns for self-defense, and yet a lot of the literature coming from the NRA, a lot of the advertisements coming from the NRA, seem to suggest that you are a Second Amendment rights organization. I mean, you have close ties to the Second Amendment Center. You have the Institute for Legislative Action that has a huge interest in promoting the Second Amendment. And I guess I'm wondering then, are you promoting the militia context of the Second Amendment then, if that has nothing to do with self-defense?
We're promoting the civil rights side. We are the oldest civil rights organization in the country. When you have a right that's guaranteed by the Bill of Rights, that's a civil right. So we are promoting the civil right. And we'll get into the bifurcated, if you'd like to, we can get into the bifurcated clause of the militia and so forth. But what I'm saying is that I don't know where this 2%, I don't know how there's 100 million gun owners in the country today. I'm not sure how you can come up with a study or, again, we're always we don't do any studies or surveys. Nobody should believe us and we don't believe anybody else because you have 100 million gun owners and I don't know how they find out that 2% own them for this particular reason when you don't take a survey when you buy a gun and there are 400 million guns in the country. So I do object to any type of survey that says why people do so forth. But again, we are a civil rights organization, and that's why we do what we do, is you have a civil right. Whether you want to exercise it or not, we don't tell anybody to buy a gun. We just say, if you choose to, we are the organization that's going to defend your right as intended by the Constitution.
All right, thank you.
Okay.
In 1991, former Supreme Court Chief Justice Warren Burger referred to the Second Amendment as the subject of one of the greatest pieces of fraud, I repeat the word fraud, on the American public by special interest groups that I've ever seen in my lifetime. The NRA has misled the American people, and they, I regret to say, they have had far too much influence on the Congress of the United States than as a citizen I would like to see. And I am a gunman. Burger also wrote, the very language of the Second Amendment refutes any argument that it was intended to guarantee every citizen an unfettered right to any kind of weapon. Surely the Second Amendment does not remotely guarantee every person the constitutional right to have a Saturday night special or a machine gun without any regulation whatever. There is no support in the Constitution for an argument that the federal and state governments are powerless to regulate the purchase of such firearms. What former Chief Justice Warren Burger is getting at, from an opinion of the Supreme Court, from an opinion of the law, is that the Second Amendment pertains to a militia. And yes, that is a civil right that was thought to be a very legitimate thing in 1776 and then when the amendment was written in 1791. However, in modern times, the militia and preventing tyranny against the government seems like a very far-fetched, very dangerous, very reactionary and radical at the same time sort of thing. It seems like something that not many Americans associate with. Mrs. Anglewicz questions the idea from a Pew Research poll that says that only 2% of Americans identify their gun ownership with expressing their Second Amendment rights. But simply what this is basing itself off of is from thousands of gun owners who say, I own my gun for self-defense. I own my gun for hunting and sport. I own my guns to collect memorabilia and to collect antiques. I own my guns to express a Second Amendment right to perhaps one day be able to rebel against the government. And that's a very small number. The number of people who are in a militia is even smaller, about 30,000 individuals in the United States by some estimates. What we see when we look towards this is that the people who identify with this sort of right are the people who identify with the Second Amendment. But the Second Amendment that the NRA promotes, the Second Amendment that the NRA gets people to go out in front of the Capitol, in front of different state lobbying groups, in front of different state political organizations, in front of different lawmaking institutions, to protest and say, protect my Second Amendment rights, don't touch my guns, it's my constitutional right. That Second Amendment is not the militia. There is no good faith effort by the NRA to make sure that when people scream about their Second Amendment rights, that they're actually screaming militia rights, that they're actually screaming about this civil right to the common defense. Yes, there is a reason for a right to self-defense. It's a very important reason that, as Mrs. Anglewicz has conceded, does not exist in the Constitution. That ought to be in the Constitution. But the Second Amendment that people champion with different posters and different slogans is not the one that the NRA actually promotes, and it's not the one that the constitutional founders intended.
Can I ask questions? I'm sorry.
We were planning a speech.
I will do that. I apologize. He touched on really great points, a couple really, really great points. I could certainly stand here and I can quote Scalia and Roberts and Thomas, and I could certainly do all that, but that's not going to help any of you understand the issue better. So what I want to do is I want to mention a few things. He mentioned machine guns as being part of something that people say it's okay to use, and I think I want to be very clear that machine guns have been heavily regulated and prohibited since actually manufacture from the National Firearms Act of 1934 and then any manufacture after 1986. So I just want to be very clear that when we talk about current gun control debates, that's not what we're talking about. He mentioned the term reactionary, and that's something that we want to get away from. The problem that we're having is that the Second Amendment is very clear. The Second Amendment is clear as an individual right that you have a right to keep and bear arms. We know what each of those words mean. We know what militia means. We know what arms means. I certainly reject the notion that people should or should not only own guns if they're going to be part of a militia or not be part of a militia. The bottom line is that every court, including the Supreme Court, says that you have a right to keep and bear arms, bearable arms. Now, we could get into a lot of the bearable arms and the reactionary thing, but I think that it'd be important to take the debate somewhere to see where if people want to amend the Constitution or amend the Second Amendment, which is being suggested here tonight, how would that at the end of the day help our nation today? I think that's where we need to focus the debate on, is if that's what's being projected as saying we need to amend the Second Amendment to do something, we need to ask, well, what do you want, how do you want to amend the Second Amendment, and how will that help anything? Because I feel like if we get away from the militia clause and saying that, again, it's been settled that you can own a firearm regardless of belonging or membership to a militia. But if we're going to talk about a topic of, which we'll eventually, I'm sure, get into, is modern gun control debate, I think it's important to understand how specifically we would amend that and how that would help gun ownership or help with gun violence challenges or gun accident challenges. So, and that's it. Great.
Would you like to ask the first question? You said you had a question in mind.
I just had a question as to, and just I guess what I posed at the end was, you suggested that the Second Amendment needs to be amended, and that's sort of your end goal.
Right, right.
So amended to say what and apply how?
Well, I'm not going to propose specific language, but amended to contextualize the right to keep and bear arms in terms of self-defense.
Oh, okay. And we would, okay. We both agree on we have a human right to self-defense. Is that?
Yes,
okay.
And so now I have to ask, obviously we can't own nuclear arms.
Correct.
And generally it's a pretty moderate view to say that we can own handguns. So where is the line in between?
Well, the way that the Supreme Court has defined self-defense is being able to use a tool that is commonly used is basically the term that was used in Heller and McDonald, that what is commonly used for self-defense purposes. And in the modern times, it is a handgun. And it'll be interesting to see what happens further, and that's going to be a further legal debate about what is a reasonable, and that's going to be a term that's going to come up a lot. But yes, handguns are the most common form of a tool used for self-defense. Therefore, that's why it's accepted by the Supreme Court as such. But I am curious, though, if the bottom line here is that we need to amend the Second Amendment and have it apply in a certain way. I'd like to know specifically, how would we amend the Second Amendment from what it is today? What would it say? What would it look like? But how would we apply it in still protecting an individual right?
Well, I think that you could still much more directly protect an individual right through something that doesn't promote something that seems rather anachronistic to most Americans, something that seems rather dated to most Americans. Because the Second Amendment is very explicit about its relation to a militia right now, And if we phrase it in terms of common defense, in terms of self-defense, it being the only amendment that has a stated purpose, if its new stated purpose could be something about self-defense, then very clearly people would be able to own weapons such as handguns that could reasonably be used for self-defense, but weapons that were more aggressive than that that had significantly more firepower and that did not have any significant added benefit to your self-defense capabilities would not be subject to constitutional protection.
So what types of firearms do you find acceptable for self-defense, and what kind do you find unacceptable? You said more firepower, but specifically, how would you draw that line?
I mean, specifically, I think that that's something that's subject to expert testimony. I think that that's something that's subject to studies, to people testifying before Senate and House subcommittees. But I think that we can say that having a 30-round magazine isn't necessary for self-defense, and being able to fire a significantly more rapid amount of bullets per minute than traditional handguns isn't necessarily necessary for self-defense.
Well, it's very important here that there has been much testimony and expert testimony on each of these firearms, and I am very, very well versed in exactly how each of these work. So, but that's important when you're talking about a constitutional right. You pick and choose a firearm, and the problem is people are picking and choosing firearms without having a clue how they actually work. So we'll use an example, and I'm sure this. So would you say that an AR-15 should not be protected by the Second Amendment?
I'm not qualified to say that any particular gun should or should not categorically be protected by the Second Amendment. However, my understanding of an AR-15 is that it is a semi-automatic rifle that fires incredibly rapidly. I understand that it is a weapon of choice that people use for self-defense, but I also understand that similar ends can be met through handguns. I mean, the idea of self-defense is that you only need to fire it at a bad guy. You don't need to fire 60 rounds. You don't need to fire anything with an incredibly high cartridge size.
So are you saying that people should be allowed to have handguns but not rifles?
Well, I wouldn't want to say that no rifles are allowed. Rifles are popular for hunting. Rifles are popular for sport, and many rifles, in fact, have a less lethal capability than handguns and fire slower than handguns. So I wouldn't want to say anything categorical like that.
I have a handgun with a 30-round magazine. I have an AR-15 with a 30-round magazine. I want to explain how a semi-automatic firearm works. When he keeps saying the term rapidly shooting, it is not rapid. And I'm sure many of you are thinking a fully automatic machine gun, which is not what we're talking about. I just want to be very clear. A semi-automatic firearm, which he correctly identified, is one pull of the trigger and one bullet. That's it. That's all. It doesn't fire more rapidly. It doesn't fire quicker, faster, bigger, stronger. It's been demonized, and they've labeled it an assault weapon when it's a semi-automatic rifle. He mentioned hunting. I have a 30-06 hunting rifle that I shoot deer with. And I will say this, that in the state of Virginia, it's illegal for me to hunt deer with an AR-15 because the bullets, the power is not strong enough to kill a deer. So your traditional bolt-action hunting rifle is more powerful than an AR-15 and fires exactly the same. And that's an important point to make, because if we're going to start proposing, picking and choosing certain types of firearms that people who have a constitutional right to own based on how people think they look, because they look scary or they look like they could, we need to be very clear about terms if we're going to have a debate about that.
And my point, I don't want to be misconstrued here, my point is not exactly that an AR-15 is necessarily the weapon that should be banned or is necessarily more or less dangerous than a particular handgun or any kind of bolt-action gun. I'm also not saying that there are no bolt-action guns that I think should necessarily be safe. I'm not necessarily saying that all bolt-action guns should be free and clear either. I mean, I suppose just to wrap up is that I'm more saying that there are some. I mean, I'm not looking to pick and choose, and I'm not looking to advocate on any particular gun. I think the question in line is, where do we draw the line and how do we do that? And I'm not coming from the position of expert testimony to express that, but at the same time, I don't see the need to be able to self-defense to be able to buy a gun at a gun show without a background check. I don't see any harm to self-defense to having extended background checks. I don't see any harm to self-defense to say that you don't need a 30-round magazine. And I'm just throwing those out as examples, but I understand I'm not qualified to say that any particular firearm should be disallowed. I'm more saying that the framework that we need to look towards is this a gun for self-defense? Yes. Does it cause more harm than good? Let's evaluate that. Is it a gun for self-defense? No. Well, is it something that is a credible threat to society and there would be fewer harms if we banned it? Then maybe we should consider regulating it in some sort of fashion.
Any gun, regardless of type. It could be a 22 caliber that's this big. It could be a 50 caliber BMG. Any gun in the hands of the wrong person can be incredibly dangerous to anybody. Absolutely. I don't care if it's, like I said, if it's a BB gun, it could be harmful to somebody. But the guns in the hands of somebody like myself as a responsible gun owner isn't going to hurt anybody. I could bring the biggest firepower you've ever seen in your life, and I can put it on this table, and it will sit here in perpetuity and not harm anybody whatsoever. So when we start talking about drawing a line on certain types of guns, that's the wrong focus for this debate. It's the wrong focus for the gun control debate, because we shouldn't be focusing on a type of firearm thinking that it's got a bigger bullet. We should be focusing on the people and the hands that it gets into their hands. The debate should not be focused on changing the Second Amendment to say what we want it to say, because even if it gives you that warm fuzzy feeling about the Second Amendment at the end of it, how is it going to affect your rights? And so my ultimate question is that, what is your end result? What if you were able to change the Second Amendment, what would be the end result for you that and how would that make anybody safer or change anything? Because again, it's not about the caliber of firearm or how it fires or how many bullets you can have, because that doesn't matter at the end of the day if it gets into the hands of the wrong person. So I'd like to know what the end result would be in the utopian world of a great Constitution.
I will address that in this speech. So the question coming up today is, how would amending the Second Amendment to contextualize it in terms of self-defense actually help? How would it help more than harm? And I think we're losing sight of that, because changing the Second Amendment to be phrased with respect to self-defense means that if a gun, through expert testimony, through industry experts, through public opinion, is deemed to not be necessary for self-defense, it is no longer protected under the terms of the Constitution. If a knife fails under that standard, it is no longer protected. If any means of offense is no longer protected under that standard, it would fall. And if it was categorized as an arm, if it was categorized perhaps as a firearm. And so when we look towards how amending the Constitution helps, what we need to realize is that characterizing this in terms of self-defense means that a gun that has 30 rounds in its magazine might not necessarily be necessary for self-defense. And regulating it might make it harder for criminals to commit mass murders, might make it harder for criminals to commit massacres. As we saw in the shooting of Gabrielle Giffords, the suspect was taken down when he had to change magazines. This is the sort of thing we notice when we see that people having to change magazines, having to use a smaller weapon, can still cause harm. But they cause less harm. Perhaps if someone had to use a different gun in New Haven, Connecticut, if the shooter in New Haven, Connecticut had to use a different gun because he couldn't have accessed the semi-automatic gun that he used, or perhaps if he had to change bullets more often than the security officer who wasn't there right at the time that he started firing could have made it there before he shot as many people as he did. When we look towards what amending the Constitution does to phrase it in terms of self-defense, we see that we have more options to pull guns that are strictly offensive, or at least that have offense as their primary purpose and that do not provide any significant benefit to the ends of self-defense. And that makes us a safer society. And it's consistent, and it's wrong for the NRA to keep saying that the Second Amendment says otherwise, because the Second Amendment talks about a militia. So if we want to look towards the Second Amendment with respect to the civil right of a militia, then there's really no reason to end the discussion at semi-automatic rifles. We should really be having a discussion about weapons of mass destruction, because that's what a modern-day militia would need today. Yes.
Okay. So the bottom line is what he's proposed is an absolute impossibility. Regulating firearms, changing the Second Amendment, regulating certain types of firearms is not going to stop a criminal madman from doing what they intend to do. That is the bottom line. They are not going to oblige to the new terms of the Second Amendment. They're not going to oblige to a new law that says, oh, if I can only use 10 bullets, I'm not going to commit that crime, but if I can use more, I am. The problem is that criminals, and he talked about safety, and that's the bottom line for both of us. We're on the same page. The bottom line is that we need to be safer and make sure guns don't get in the hands of the wrong people. Going at it to try to undermine the Constitution or regulate certain types of guns isn't going to make anybody safer. What's going to make people safer is compelling governments to take action, making sure that the background check is good, not expanded, but it's effective, and we lobbied to do that. We created the system that compels that any time you purchase a firearm, including at a gun show from a dealer, you have to go through a background check. Those are the things that are going to make us safer. Not deciding that some imaginary test that, well, yes, that could be used for self-defense and that can't be. How could you possibly create a test to decide that this gun is fit for self-defense and this gun is not? Who knows what situation you're going to be in when you need this many bullets or that many bullets? Do you say that, well, you should only need 2 bullets? What if you have multiple intruders? What if you're protecting your children? What if you have people coming at you from a distance? How would you possibly create a test to determine what types of weapon is deemed fit for self-defense? But in a free society, that's the wrong question to ask anyway. Again, our bottom line that we would agree on is that we have to be safer. Our approach is completely opposite. Our approach is you focus on making sure that guns do not get into the hands of violent criminals, those that have been adjudicated mentally incompetent, people that are prohibited from having guns. You prosecute people, you prosecute them for straw polls or straw purchases. That's how you do it, not by amending or changing the term self-defense or changing the Second Amendment.
So, any of the laws that have been presented does the NRA support any of the laws that have been presented in Congress over the past few weeks?
Well, as a matter of fact, we were supporters of actually 4 amendments that were put on that bill. None of them passed, and let me tell you what those were. Those would have enhanced the background check system to compel the states to give information about those adjudicated mentally incompetent into the system. That failed. We actually asked for more money for school safety. People could become trained and assess their schools for school safety. That failed. We asked that people be prosecuted for straw purchases. That failed. So yes, we not only did we support some of the amendments, we actually worked with the sponsors of that amendment. So yes, we 100% believe that the background check system needs to be improved.
So then, what sort of restriction, or I'm sorry, what sort of pieces of legislation would you support then to make sure that purchases at gun shows are treated the same as any other gun purchase?
Well, the reality is that anytime you purchase a gun from a gun show, from a licensed dealer, which is 98% of the people at the gun show, you have to go through a background check. If you don't, it's a federal 10-year felony, of which, quite honestly, our Department of Justice is not prosecuting. So we believe that you need to be prosecuted if you don't go through a background check. If a gun dealer sells a gun to somebody without going through a background check, they should be prosecuted. They're not. If I sell a gun to somebody that I know or I should know are prohibited from having a gun, I should be prosecuted, which is, again, a 10-year felony.
Okay.
We believe in enforcing the law, and that's not being done.
We do agree on that. If 30-round magazines cease to exist and guns that hold them also are no longer produced, would it be harder for a criminal to acquire them? Someone who's looking to go into a situation where a 30-round magazine would be desirable, would it be harder to acquire it?
Well, the reality is that in these unfortunate mass shootings, that they didn't shoot all those rounds. Those magazines weren't empty, so it didn't matter if they had a 10, a 20, or a 30. They had multiple firearms. If a deranged madman is hell-bent on committing an atrocity like that, they aren't going to say, well, the law says I can't get a 30-round magazine. The bottom line is there are hundreds of thousands of them. Criminals don't get guns or magazines through regulated channels, so you can regulate them all you'd like.
For sure, but the supply dries up. And the shooter of Gabrielle Giffords and the other individuals at her event, he had to change magazines and was tackled in the process.
Well, I don't know how familiar you are with shooting, but the reality is some of that's not substantiated, especially with the Gifford shooting, because that wasn't the case. But it takes less than a second to change a magazine. I can do it in probably less than half a second.
Yeah, for someone very, very well trained,
right,
for an expert.
But these folks have been shooting, and they knew how to shoot. So the reality is, again, we're focusing on the wrong thing. I have many 30-round magazines, and they don't dry up because they're reusable. Unfortunately, a lot of the lawmakers that are creating the legislation actually think they're not reusable, but they are. So, but again, that's not going to change anything. That's not going to stop an atrocity from happening. Even if we were to just wave a magic wand today and ban every 30-round magazine moving forward, it's not going to stop this from happening again unless we start focusing on the right thing.
Well, on to my speech. I want to make sure that we don't lose sight of something that seems very interesting to me, which is that the NRA does a great job in making sure that people go out and say that people want to trample upon Second Amendment rights, that gun regulation advocates want to trample upon Second Amendment rights. But it seems like the things that we're discussing today have very little to do with the Second Amendment, with a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. It seems like what we're discussing today is a very fine line of, okay, does this magazine size optimize safety or does it not optimize safety? In what situations would this be good? In what situations would this be bad? What about an AR-15? What about an M10? It seems like what we're discussing today actually has quite a bit to do with the ideas of self-defense and not to do with the Second Amendment. The Second Amendment pertains to a militia, and we haven't heard much to contest that. While the Second Amendment does indirectly say that if you're going to be in a militia, you might need to own a firearm, it doesn't talk about self-defense, and it talks about the purpose for owning that firearm being for service in the militia, not being for perpetrating self-defense and for preparing to defend yourself. When you look towards the Second Amendment, and when you look towards what the NRA makes people think the Second Amendment is, there's quite the mismatch. The NRA has perpetrated a mythical Second Amendment that says that these guns with 30-round magazines are protected constitutionally. She said it at some point during this debate that we don't want to trample upon Americans' constitutional rights. But that's the fraud, that people who think that the NRA leads to people thinking that these different laws trample upon Second Amendment rights, and that these different laws do that, when these different laws are concerned with public safety and self-defense. And the constitutional right is not being touched at all. The constitutional right concerns a militia, and it's about as outdated as the Third Amendment regarding quartering soldiers. It seems like it would make quite a bit of sense to change this to what the debate has sidestepped to, which is self-defense, and then maybe we could make sure that other Supreme Court justices don't side with the dissenters in the case of D.C. v. Heller. Maybe we could come to some sort of agreeable compromise under that. Maybe we could look towards a situation where guns that are optimized for self-defense are allowed, guns that are not optimized for self-defense are not allowed. That's something that's decided through industry experts, public opinion, and industry interests.
Well, the NRA hasn't perpetrated anything mythical. What's mythical, I guess, is me trying to figure out how we would amend a Second Amendment and why and what and for what reason. I can't get a bottom line as to how that would do anything or help anything in the cause. So without an actual argument, it's difficult to say much, but I will talk about the militia, since that seems to be the only sort of thing, is that we can focus on the bifurcated clauses all night long. But the reality is it's a convenient argument, but it's entirely incorrect. And beyond that, looking at history, looking at the context, judicial precedent, all of the ways that you could analyze the term militia, which I could have just done alone tonight, but you would all have been sleeping by now. But they all lead to the same result about what the Second Amendment means. Nullifying the opening clause of the Second Amendment with the term militia does not nullify the whole sentence. There are grammarians who have written books on this, and if anybody would like them, I will point you in the right direction. But if these terms, like militia or well-regulated, are confusing to anybody, these days, it's not because James Madison, the author of the Second Amendment, was ambiguous. It's anything but. It's only confusing because it's the only argument that the gun prohibition people can spend time on confusing citizens with, because they have no other substantive argument about what the Second Amendment means, because again, the legal academy has rejected all of that. Now, yes, there's going to be a professor here, a professor there that's going to write something, but the bottom line is that you can't just pick and choose what parts of papers or law reviews you want to read or regurgitate. You have to really understand historical context, and that's what needs to be done here again. If people are confused about the term militia and the Second Amendment meaning, it's not because James Madison wasn't clear. It's because the gun prohibitionists really have nothing else to hang their heads on, and they try to confuse people to think that the right of the people should mean the right of the government. Is that the end?
No, I did have.
It's a speech by me, 3 minutes, and then
we're in the fourth round, and I guess we could move to a questioning of about 3 minutes. Just get the okay. So I agree with you in saying that James Madison was not ambiguous, and when he wrote the Second Amendment. I mean, there was plenty literature to guide him in the right direction. There were the Pennsylvania and Vermont constitutions, which said that self-defense and common defense were constitutionally protected within the state. And then there was the Virginia plan, which said that there was strictly a militia protected, at least in the formally by the Constitution. And James Madison very clearly went with the latter. There was constitutional debate promoted by Thomas Jefferson about including something about self-defense, and that ended up not going in there. My problem with the NRA comes from this idea that the Second Amendment protects guns that relate to self-defense when that's nowhere in the Second Amendment. And I feel as if the NRA wanted to claim self-defense, if the NRA proponents wanted to claim self-defense via the Constitution and via this great law, they'd have to really find it in the Constitution.
Well, not only is it in the federal Constitution, but there are 44 states in the United States that have their own militia and right to keep and bear arms clause, just to be clear. But I understand your point. The reality is that the Second Amendment, okay, just to be very clear, the Constitution does not give you a single right. You are not assigned rights by the Constitution or the Bill of Rights. As an American citizen, you are born with rights. The Constitution and the Bill of Rights exist to merely protect those rights. So we have to be very clear in that. Yeah, well, that's just how it is. And so the reality is that when we say self-defense, we can't really occupy that territory because that's called a human defense. So you're born with a right not only to defend yourself, but you're born with a right to keep and bear arms, and that's why it was written that particular way. Now, if we're going to say that the Second Amendment is irrelevant today, that's a different argument.
I mean, I understand how you can say that you're born with a right to defend yourself, and I, to a great extent, agree with that. If someone hits you and you're cornered, you're born with a natural right to respond, to protect yourself. And I understand that. I don't think that you're born with a right to own guns. I mean, we're talking about a relatively new historical advent in the entire case of humans being born.
Well, that was the beauty of the Constitution. See, we are a mere infant compared to the rest of the world, the United States is. But when we go there, if you're going to sort of make the notion that if it wasn't in existence at the time that they wrote the Second Amendment, that it's no longer relevant, is that you're saying it doesn't apply to modern firearms, or it should only be muskets, or
no, I'm not saying that. And what I am saying is that the right to self-defense doesn't appear in the Constitution, and we're placing it as this great right that for whatever reason is not in the Constitution. When Jefferson and Madison debated about whether to put it in, I think it would be pertinent to put it in the Constitution in modern times, and yet it's, for whatever reason, not there.
There's there's a lot of things that aren't in the Constitution. For those of you that think you have a right to privacy, there is no such thing in the Constitution. But a large majority of your individual rights today are based on a collective notion of you have a right to privacy. There are a lot of things that aren't written into the Constitution that are considered rights these days. So you can't ignore history, collective history, and Supreme Court cases and all sorts of scholarship that has established that the ability to defend yourself with a firearm is the accepted notion of self-defense, which is exactly why using a firearm is part of that. There are different ways to defend yourself, and using a firearm is accepted now in that notion.
D.C. v. Heller and Chicago and McDonald are only, in 2008 or 2010, are the first instances of that actually being tied to the Constitution.
Well, why do you think that? You said, and that's a very important point, 2008 was the first time our Supreme Court ever took on the meaning of the Second Amendment.
Well, no, it took it on in Miller, it took it on in Cruikshank.
It did not squarely take it on, absolutely not. Not the Second Amendment. It took on the right, what the people meant in Cruikshank was what that meant. In the Miller case, they talked about the militia clause, and they talked about federal firearms law. But in no case did they ever take on the meaning of the Second Amendment until 2008, and there's a reason for that. The reason is that we didn't need to, because it's been intuitive through our entire history what the Second Amendment meant. When I started this debate by telling you it was a manufactured debate, it was a manufactured debate because they wanted to pass gun control legislation. And they didn't have any other way to do that except to start undermining the Second Amendment to the Constitution. Political motivation is exactly how this was manufactured, and is exactly why it ended.
I don't think we've always tied the Second Amendment to self-defense, though. When you look towards the Miller decision, it ended up being ruled it regarded whether or not an individual could own a sawed-off shotgun. And the overall decision was, well, that's not something that you need for a militia, so you don't need to own the sawed-off shotgun. And that has, that's the final verdict that we're talking about, and it has very little to do with self-defense.
To be clear about the Miller case was the Ninth Circuit case that has been obliterated by Heller and McDonald. But what's interesting about the Miller case,
you're saying that precedent exists.
Well, the interesting thing about the Miller case, well, it's interesting because both sides claim victory. We claimed victory essentially in the Miller case, as did the other side, because what happened is just to let you know, the Miller case is the court refused to rule on the individual nature of the Second Amendment and the militia clause squarely. And so because they didn't, we said, well, they could have, and they didn't, therefore they know what it says. And they claimed, well, this is, so just to be clear, that the Miller case was a leading case in 1939. It was not a Supreme Court case, it was a Ninth Circuit federal case that only applied to the Ninth Circuit. But again, it's been obliterated by Heller and McDonald, which is the prevailing law. But it's interesting that it constantly gets brought up, a case from 1939 that is no longer relevant in this scholarship because of Heller and McDonald.
Okay. I think we'll move on to the fifth.
Okay.
Just bounced around a little based on what seemed convenient. Being sidestepped today is the question of what Americans identify the Second Amendment with, based upon what the NRA promotes that the Second Amendment is. What's become very clear today is that the NRA agrees that the Second Amendment, historically, has not been related to self-defense. We actually heard that the Second Amendment earlier today has no relation to self-defense other than through an indirect link through the militia requiring that you own guns, but that the firearms that you own were contextualized for the militia, not for self-defense. I'm being asked constantly why I would want to amend the Constitution to contextualize it in terms of self-defense. And that's because once we do that, then we can actually consider regulating guns or not regulating guns based upon whether they are optimized for self-defense conditions, based upon expert testimony, based upon public opinion, based upon industry opinion and industry interest, the same way that we decide every other public policy decision in the United States, rather than deciding it in these lofty Supreme Court decisions. But that's not what happens right now. We fail every law in the public policy sphere, and nothing gets through the Senate because everything gets filibustered, and then we look towards laws at the Supreme Court level, and in 2008 and in 2010, they get destroyed. Now, she's right in saying that the McDonald and Heller decisions obliterated the Miller decision, and that just goes to show us that The Miller decision is precedent that says otherwise. If it obliterated it, then Miller was different. But she's saying that 200 years of precedent have told us that we have a right to self-defense via the Second Amendment. And that's just not the case, because if Heller and McDonald destroyed it as she said, then clearly there was significant precedent in the leading case up until then, Miller from 1939, which stood for quite a bit of time, almost 70 years. What I think we're losing sight of today, though, is that Americans identify with the Second Amendment on self-defense. And she's saying that I am just manufacturing an argument to say that the Second Amendment is related to a militia, but it's plain text, a well-regulated militia being necessary for the security of a free state. And my issue is that while only 2% of Americans own guns to promote their Second Amendment interests, so many think that it would be so difficult to touch gun rights and to touch gun ownership because the Second Amendment must protect it via self-defense. But self-defense is a question of public policy and what meets the terms of self-defense.
There is, just to be very clear, there is a direct link to self-defense and firearms, because the overwhelming way in which people defend themselves in the United States today is by use of a firearm, which is why we defend that right. So there is a direct link. I'm not sidestepping that in any way, shape, or form, so just to be clear. He mentioned a 200-year debate. It's not a 200-year debate, again, and I'm not saying he's manufacturing a debate. This debate has been manufactured to support gun control agendas because there was no other way to do it. So the debate is actually very new. The debate didn't really start until the 60s, and it happened because of tragedies involving guns and promulgating bad laws, and they had to have support for them somehow, so they had to change the Constitution because they knew they'd be thrown out, or they wanted to get that point across. So this isn't a 200-year debate about the individual notion of the Second Amendment and so forth. This is a new debate, a modern debate that has really just been put to rest. And the debate has shifted significantly moving forward. So,
we're going to do one more set of questions and then the concluding statements.
Yeah,
okay.
whatever you'd like to do, yeah.
So, when the NRA tells people that they protect Second Amendment rights, do you mean that in the context of a militia, or do you mean that in the context of a categorical right to keep and bear arms?
Definitely not in terms of a militia, because your ability to keep and bear arms is not predicated on your membership in a militia. So 100% no.
Okay.
Okay.
Well, my point for asking this is that then is it based upon self-defense? Is it based upon hunting and sport?
It's based on a civil right for your ability to keep and bear arms for defense, for common defense. And the common defense is a broad term.
Like a militia.
Well, no, common defense could be defense of your home, defense of your family, defense of your country, defense of your community. And that's what the term meant, was common defense. If the founders wanted to say the right of the states to have arms, the right of the armies to have arms, the right of the National Guard, which wouldn't apply because that wasn't founded until 1903. But the reality is that the founders could have used any word they wanted, army, states, anything. But in that period of time, militia just meant the whole body of people. That was the definition. So again, the confusion on the term militia is going to keep being perpetuated because it's the only argument that is confusing enough in its language. But the reality is that the Second Amendment is about your ability to keep and bear arms for defense. And defense has been defined to include a lot of different ways of defense, whether it's defense, again, for yourself, for your home, for your family, for your community, for your country. And so that's what we say, is if you decide to keep and bear arms, bearable arms, we will defend that right for whatever purpose is allowed, which are all of those purposes are allowed under prevailing historical text.
So I understand that the Second Amendment comes. I suppose you're saying that it's not necessarily ambiguous, and I think it is rather clear. I feel like I've already gone over this. The Second Amendment had legal precedent to look towards. James Madison could look towards Pennsylvania and Vermont, which explicitly said self-defense and common defense juxtaposed against each other. But then we looked towards Virginia, which had a militia plan, and that's what James Madison went with. Thomas Jefferson presented the opposing viewpoint and said, why don't we have self-defense and common defense? However, James Madison, when he wrote the Constitution and got it ratified by the states, decided to go with what we have. Just militia. Nothing stating common defense, nothing stating self-defense, when he had all the options presented before him, and the states had all the options in terms of what to ratify.
So the bottom line here is that you want to ratify the Second Amendment to get rid of militia, the term militia, and say that the right of people to keep and bear arms for self-defense purposes. And that's what he won't say, but that's essentially what I'm finally understanding, is that we want to get rid of the militia side and just say you should only have guns for self-defense. Is that correct? Is that your bottom line argument?
That's not my bottom line.
Well, what is your bottom line argument?
Well, my bottom line argument is that you can have guns that meet the ends up to self-defense. If you want to use your rifle that you use for self-defense to hunt, then by all means.
But that has nothing to do with self-defense. So you're saying you should, so that it should be then amended to say you can have guns for self-defense and for hunting.
No, that seems to intentionally obfuscate it. I'm saying that you can have weapons for the purpose of guns that you need for self-defense are constitutionally protected.
So what's a type of gun that would be acceptable under your test? If there was a
as
test,
I understand, many handguns would pass under that test. As I said, I'm not saying that I want a categorical ban on handguns. As I understand, many handguns, many rifles would pass under a general self-defense or less test.
So in changing the Second Amendment, what are we trying to stop from happening? I mean, if the end goal is to change the wording of the Second Amendment to do something, what is the effect that we're trying to do?
Well, if you change the Second Amendment, then these laws that currently fail and the opinion that the Second Amendment protects these rights of self-defense actually become both legitimized. And the ability for people on the left side of the gun issue to say, let's take away more guns, gets a stop at self-defense, and people on the right side of the gun, on the conservative side of the gun issue, have a different framework to work with, which is guns for self-defense are guaranteed, and anything more has to be argued for at a public policy level.
But if that's the end of your debate or the final point, there has to be a test then. How would you then pick and choose, which you say you don't want to do, but you'd be forced to?
Well, I say that I personally don't want to be the person doing the picking and choosing, but I think that it's kind of unreasonable to expect me to say AR-15's gone, AR-10's in, M10's gone, 30-round magazine's gone.
But that's what you're forcing. That's what the politicians are being forced to do.
That's what I would expect industry experts.
I'm an expert on many firearms.
Yes, and I would encourage then a future debate between yourself and someone from, say, the Brady campaign, or from an industry expert, or from an industry opinion and public opinion, to weigh in on a debate that says, all right, this gun today, let's weigh in on whether this gun is good or not, in front of a Senate subcommittee and a House subcommittee so that they can make a well-informed legislative decision.
Well, they did that 2 weeks ago, and it failed. They actually had a list of 197 guns that they wanted to ban, and it failed.
But it failed because of a misconception as well with what the Second Amendment protects.
Well, no, not really, because the reality is that argument about what the Second Amendment means, even I have debated a Brady attorney, and they've conceded that the Second Amendment's an individual right. They don't even argue that anymore. Their argument is what types of firearms should be covered that are reasonably or commonly owned, and that's the debate. The debate is no longer about militia or about that sort of thing. But the reality is that when we talk about an individual right, this is not a privilege. We're not talking about, I certainly don't ask people, why do you go to church every Sunday? Why should people under constitutionally protected right ask me what type of guns, why do you own that type of gun? They all fire exactly the same. They look different. But when we're talking about these so-called assault weapons, of which there's going to be this mythical test of which one is good for self-defense, one is not, every single gun could be used in self-defense situations. So therefore, I don't know how you would possibly determine one. You may have a 300-pound man coming at you, of which you need a .357 Magnum. You may have a deranged drug addict who weighs 100 pounds, of which you may only need a .22. So it's a mythical test that is an impossibility, but again gets away from the entire point of the ability to pick and choose, and why we would even need to, because in a free society, you don't ask people why they own a certain type of gun, or why they're a certain type of religion, or why they have a certain type of opinion. In a free society with rights that are protected, You don't ask those questions, and this would force them to pick and choose guns, which Congress does, based on they look scary. They don't know how they fire. They have absolutely no clue how a firearm works. They have no respect to even learn how to do that. But they pick and choose firearms because they look scary, and that's how they choose to ban. Not because one's good for self-defense and one's not. They pick and choose them because of their cosmetic features. And that's what is a dangerous, slippery argument to make about banning certain types of guns, because at the end of the day, you're restricting your freedom.
We can move on to the last round of speeches and audience questions.
All right.
I want to get back to this idea about common defense. And there seems to be really a misconception, I think, coming from the NRA position that common defense means self-defense. I suppose you could link common defense towards protecting yourself from tyranny of the government, so protecting yourself, but common defense does not mean protecting your home from invasion, except from anyone. It only refers to that with respect to the government and with respect to tyranny. It doesn't refer to that with respect to a murderer. And I think that you need to be able to protect yourself against a murderer, but I don't think that that appears in the Constitution. But I think that the NRA tells people that it does. I think that the NRA overwhelmingly makes people think that when they present posters that say, "Don't trample on my Second Amendment rights," that the people who do that are not referring to preventing tyranny, and they're not referring to preventing government invasion and government tyranny and government oppression and foreign invasion. They're referring to their ability to own a gun to protect themselves and their families. But that's not what the Second Amendment says. And she's trying to link the Second Amendment to that for self-defense. But the sort of support that I say comes across almost as strongly as a divine inspiration from the Second Amendment is misguided, because it doesn't actually come from the Second Amendment. She said it. It comes from more of a natural human right, but it doesn't come from the Second Amendment. So this myth that the NRA has promoted, by which people say that their ability to possess certain guns, any guns, is constitutionally protected and they don't need to have any further discussion on it, is misguided. Because what the Constitution protects is guns for a common defense, guns for a militia. But that common defense is not self-defense unless it's with respect to against the government or against a foreign invasion. And that is a fraud that's promoted by the NRA. A fraud promoted by the NRA that gets people to actually believe and to wholeheartedly support the idea that the Second Amendment protects their personal ownership of guns because of self-defense, because of hunting and sport, because of this just general civil right to do so. But it informs us very clearly of what the civil right it protects your gun ownership is, of what the civil right it wants to protect your gun ownership for is. And that's the right to partake in a militia. You don't have to partake in a militia if you own a gun under this, but that's why you would do it. So if we actually still want to view the Second Amendment in terms of a militia, and if we actually still want to view the Constitution in terms of this radical document that allows us to overthrow the government violently when the government now has weapons of mass destruction, and we have a media, and that seems so inconceivable, then maybe we shouldn't change the Second Amendment. But if we'd like it to not be this embarrassing thing that doesn't talk about why we actually own guns, which is for self-defense, then let's change it, and then we can have an educated public policy debate in front of the legislature over and over and over again to make sure that we're always getting it right. That's not what we do today, and that's problematic. And the NRA promotes really a mythical situation when they tell people that their Second Amendment says otherwise. Their Second Amendment is about common defense against the government and nothing more.
What's missing from this debate is the bottom line is to have the Second Amendment say what and why. That's entirely what's missing, and that's, again, we don't hear this argument often, but that's the bottom line, is what's missing is what are we trying to have the Second Amendment say, and why are we trying to change it? We're trying to change it because it's the only argument that the folks that are anti-gun can come up with, is to change the Second Amendment, because, again, the facts are on our side. The NRA doesn't tell anybody really anything. We don't have to. There's a lot of strong rhetoric used against NRA, like the terms mythical and fraud and circular logics and those sorts of things. And that's fine. We're certainly used to it. But history stands for itself. The Constitution stands for itself. The Second Amendment was not written in disappearing ink. And it's a travesty that the Second Amendment is treated very differently than the First or the Fourth or the Fifth. And so hopefully moving forward, this is a very interesting debate for everybody, but the bottom line is if you want to change the Second Amendment, you have to say why, you have to say how, and you have to say what your end goal is. And if you don't say what that is, we can't really have an open and honest debate, whereas again, the NRA is not going to tell you anything. We only exist, again, to protect a civil right.
Now we will open it to audience questions if you have one. I suppose could you step into an aisle, and then that'll be a good way to...
You can just stand.
Yeah, okay,
yeah.
okay. If you
Yeah,
have
I
one,
mean,
raise your hand so that it... Go ahead.
This question's for both of you. How do you guys feel about the concealed carry laws in Texas, about the ones that come through that are about concealed carry on university campuses?
There was a huge day in Austin, obviously on Saturday during our thing. And as far as carry conceal on campus, our bottom line is that, again, when we talk about carry conceal on campus, these are folks that are 21 and over that have a proper carry conceal permit, that have gone through all of the regulations and so forth. So we accept that as proper legislation. We support that. We believe that you don't check yourself to right to self-defense when you walk across a border. So we supported that legislation.
I find it to be problematic. I mean, where she just said, for one, let's talk about a technical difficulty. It's only for people who are, only for people who are 21 and older, which sounds rather problematic since that's only about 25% of university students, which means that 75% of university students now can't have guns, but 25% can. That seems like quite the inequity. But on a more basic level, I don't think it's a good idea to place guns in classrooms full of people, because every day for 8 hours this room is full of 135 students, and I would never want flying projectiles in this room that could arbitrarily hit one of those students. I think that it's significantly safer to say that someone would tackle a perpetrator than someone would accurately shoot someone.
But just to be clear, in order to have a permit, gun owners are obviously, we have a lot of folks that are veterans who come back and so forth, but when you do have a permit, people are safe and responsible gun owners, and they do training, and you have to go through certain checks to have that firearm and so forth. In order to get in fact, there's a 9-hour basic pistol course that you have 9 hours to take before you can actually get that permit, before you can actually do that. But I just want to put this out there as a final thought, that if we were in this room right now and it was packed and an armed gunman busted through the door and started firing, I would probably imagine that some of you would hope that, knowing that I am proficiently trained with firearms, would hope that you had a fighting chance that I was able to draw a gun and take out that armed gunman, rather than just cross your fingers and hope he doesn't hit you. Just something to sort of ponder. But again, these are folks who have permits, who've gone through all the traps, the background checks and so forth. It's not just college students, but a lot of that, and I haven't looked at the law, but there's many colleges. In fact, I went to Michigan State University, which you're allowed to have guns on campus far before any of this, and there was never an issue.
And just to close from my end on that, when a shooter opened fire in front of the Empire State Building in New York City, people were shot by the police. You have police shooting guns at a shooter in a crowded area, like a classroom, like in front of the Empire State Building, and whereas only one person was the target of the shooter, it was a targeted murder, 9 people were shot by the police. We'll move on to the next question.
For me, the most fascinating part of this debate is the idea of this test. You like to refer to it as this kind of mythical test that doesn't exist a lot. But it's a really fascinating idea to me, because it's clear that we do now in the legal system use this test. For instance, there is no question about whether or not RPGs should be banned or shouldn't be banned. So clearly we already are making decisions about whether or not guns are safe for the public. So really the question about this debate is, like, for instance, why are we not born with the right to use RPGs? And the only way that And if we evaluate that question with the Second Amendment, it seems like it'd be completely logical that we would, even if you don't use the I guess demonized word militia and use common defense, wouldn't RPGs be effective for the common defense? But that's clearly not what we think in our political system. So why are we supporting? So why do we have the Second Amendment that doesn't support what we actually support? We disagree with the Second Amendment.
Well, an RPG is not a bearable arm. So the concept, again, back to the founding, the reason why they were talking about were things that people could have on their person as a civilian to defend themselves. People don't use an RPG to defend themselves. So I understand your test point, and there are tests. The First Amendment is not an absolute right. There are restrictions on the First, the Second, all of them. And so, again, when we talk about the Second Amendment, we are talking about bearable arms, not nuclear weapons or RPGs and those sorts of things, because those aren't the things that people use to defend themselves. So.
But you're defending common defense, though, not just personal defense.
But
and you
right.
can, for instance, you can carry an RPG.
Oh, well, this is a great point. When we talk about the Second Amendment, you're talking about military grade things, and those are military. The Second Amendment does not apply to things, and this is very clear, and this would probably be something you would agree with, is that when we're talking about arms, we're talking about things that were not specifically made for the military, and that was in the Heller case. So an AR-15, there's not a single person in the military that uses one, even though they call them military style, because they look like them, but they don't function like basically an M16 was, which is what they use in the military. So there's a very clear thing.
I really don't agree with that
Oh.
that last part, actually, because I feel like the Second Amendment was certainly written. I feel like we have to acknowledge that it was written in a time of wanting to prevent government tyranny, which meant the government didn't have a standing army. The people were the effective force of the nation. And if you wanted to overthrow the government, then you needed to have a force similar to what the government has. So I think that an originalist interpretation of the Second Amendment would say that we need to own weapons that are consistent with weapons that the government has, and the government has weapons of mass destruction. Obviously, I think that sounds ridiculous. I don't want people owning surface-to-air missiles. However, I think that anyone who wants to take on the government needs to be able to engage the Air Force, which I don't think you can do without a surface-to-air missile.
And he's correct. That is one of the prevailing debates today. Now, from Heller, just to say, that's what Heller said, that things that weren't created for the military. So that's the standard which we use. But what he's brought up is a new debate that came out of Heller. So it's a very interesting one, and it's one that's on both sides. People within the anti-gun, the pro-gun, they have that same debate. So it's a very interesting debate. But again, the tenets of Heller specifically said that we're talking about firearms that were specifically not created for military use. So,
Well,
but that's a very good debate that people are having right now.
To respond to that and to address your original question, when we look towards what the test ought to be, I think we find that the test comes down to, as I've been saying, I don't think that it's this mystical thing that we can never find. I think that it comes down to whether this is an optimal firearm for self-defense or not, and whether it causes more harm than not. And when you do that, I think that the tests that the Second Amendment implies are with regard to common defense and a militia, which are not similar to self-defense, and that's where we see that the Second Amendment isn't on my side, the Second Amendment isn't on her side, and yet my issue here today is that the first line on the NRA's website is that they're your news source for the Second Amendment. And so it seems that we need to come towards an agreement on what a better line is, and I fear that there are two messages coming from the NRA. One, that the Second Amendment provides us that test, most guns are pretty much free and clear and untouchable, but at the same time, it's really about self-defense. But that never seems to be the test that we actually use when it comes time to vote for a law. Then you.
This is a question for you. I felt like during specifically the time of the Sandy Hook, and even in your debate right now, you said that talks about the Second Amendment are very emotional and reactionary. And I think the sentiment around Sandy Hook was, well, let's not discuss this right now because, you know, it's infused with such emotion and we could be getting carried away with ourselves because of the time. When is the proper moment to have these sort of discussions, and why is it not relevant immediately when situations like Sandy Hook or the shooting in Aurora occur? Why is that not the moment to have these discussions?
The immediacy after that happens is the issue is that And I was in Connecticut 2 weeks ago when they passed the new laws there. And I saw the Sandy Hook parents, and it was, I can't imagine the personal pain in any way, but I knew that the laws that they had passed that day were not going to stop this from happening ever again. And that's the reality, is that the laws that come out of tragedy, I understand there's an immediate need for reaction because people cannot believe what just happened. Nobody can. The problem is that there's such an immediate need to react because something tragic just happened. And what happened is what they promulgated were laws that had absolutely nothing to do with keeping children safer. And so what we ask is not that there is ever a right time to discuss something so horrific, but what we want to do is, and we especially, is our reaction was we need to do something to keep our children safer. So we created a program called the School Shield Project, of which we are focused on because we know that's going to keep children safe. What lawmakers do is,
What is this?
the School Shield Program is essentially, the NRA is we have 90,000 firearm instructors nationwide, and that's a large majority of what NRA actually does. And what it is a program that we've created, nobody asked us to, but we created because we're best situated to train people in active shooter situations because we have 178 different training programs, and as gun owners, we couldn't be more interested in being safe and effective with it. So we created a program that Asa Hutchinson and actually SEAL Team 6 members and federal agents are all crafting it. It's a program in which schools around the country can assess their own ability to keep their children safe. Every school is different, rural, suburban, urban. Allows them to assess their situation, if they could keep their children safe in a shooting situation, and do they need an armed resource officer. We're not talking about arming teachers, we're talking about if they, and what we would do is we have a training facility. If a school decides we need an armed guard at our elementary school or high school, they would come to our training facility, we would train the resource officers, and we would provide them, the teachers, the training, again, not armed training for the teachers, but again, a very comprehensive program. So our response is that, because we know that you can go and tell, we're going to ban 127 different guns, and I can promise you that a criminal isn't going to stop and say, I'm deranged, I am mentally incompetent, and because the law says I can't have this gun, I'm not going to take it. So the reason why we feel that we have to wait is that if we are really going to do something that's going to have an effect, and not just feel-good legislation that sounds like a good idea but has absolutely no way of making people safe, that's what we want to caution against. Compelling gun registration, which is what they did in Connecticut, isn't going to stop a criminal. A criminal is not going to register their guns. They're not going to say, oh, look, the law changed today, I better take all my illegal guns and register them with the sheriff. That law is not going to make a single child safe. What may make a child safe is the NRA training people in active shooter situations. So we cautioned against a barrage of this legislation that's only going to abridge the rights of just law-abiding citizens and do absolutely nothing to address that these people are mentally deranged and they should have never been able to have a firearm, ever. But the laws that they passed in Connecticut will absolutely do nothing to stop that. So that's why we wanted to take a moment.
When you say a moment, like how long is that moment?
Well,
I feel like these happen so frequently that the next one happens after the allotted time.
Right. Well, this is different, I will say. The Sandy Hook shooting is unlike anything NRA has ever seen in its history, and we acknowledge that. We were very silent afterwards. People were, I mean, can tell you from firsthand, people were coming after us to make a statement. That wasn't the time. We were grieving. And so we don't present legislation, we don't create legislation. We just have to either fend it off or support it. So we knew it was coming, but we don't control when the legislation comes. That's not anything we do, but we were certainly ready because we knew what was coming, and we knew that if you're going to compel gun registration or ban a certain type of gun, it's not going to stop this from happening. So we went in an entirely different direction immediately. In fact, Asa Hutchinson, who is the former Undersecretary of Homeland Security, a phone call was made to him days after this happened to say we have to do something. This is, even though no one's asking NRA to do it, we knew that we are the ones that are trained to do it, and that's what we did. We did it immediately, but of course we didn't tell the media, and they wouldn't have listened anyway. So,
going back to your original question, I mean, after an incident like the shooting in Sandy Hook or the shooting in Aurora, I read something that I thought was interesting, which was it's not too early to talk about gun control in America. It's too late, which implies, you know, it has a tinge of irony to it, but implies that we should have already been discussing this. And obviously, more people are interested after a shooting, emotionally interested, personally interested, logically interested. I think that means that more people call for a national debate, and if people are calling for a national debate, we have to expect our Congress to respond, because our Congress has to respond to overwhelming demands from the American Republic. They have to at least show that they are cognizant of what the American public is shouting at them. Now, I don't think that means that we need a hasty decision. I don't think that means that we don't need expert testimony, industry interests, and public opinion to testify before subcommittees, but I think that if the public is calling for Congress to act soon, then Congress needs to look at its options right then and say, you know, it's a shame that we didn't do this earlier. And is there something we can do to prevent this in the future?
And there were two congressional hearings immediately after that were assembled, and we actually testified. We are experts. We are the folks that testify, so we did. And we will always be part of that conversation as much as possible. And we agree that things that should have been done have not been done. And we can be in agreement that it was too late to talk about mental adjudications. Just so you know, and this is something that is very important to this debate, is that, especially since you brought up Sandy Hook, is that we created the system for background checks. And the problem is that less than 20 states are compelling mental adjudications into the federal system. That's poor. So instead of Congress saying we should register guns, what they should have been doing immediately is saying we're going to give incentives to states to make sure that people that have been adjudicated mentally incompetent should have that information in the federal system so they can't have guns. But not only are the states not being compelled or offered incentives, they're not even being punished. And that's where we come in, because we're not mental health professionals at the NRA, but what we can do is we can lobby hard, and that's what we're good at. So we're going to lobby to make sure that when those congressional, you know, they're focused on a gun ban, what they should be focusing on is telling the states that you have information that you have people that are dangerous and shouldn't have guns, and you're not putting that information in the federal system so that these people in actuality can get their hands on guns. That's what we should be focusing on. But instead, Congress decided that because a scary looking gun was used in a mass shooting by a deranged person, we need to ban that gun, as if that's going to stop it. That's not going to stop it. So yes, much should have been done, and we can agree on that, and more needs to be done moving forward.
Was the Sandy Hook shooter's mother adjudicated mentally incompetent?
She was not. No,
So would that have made any difference at all?
No, absolutely not. But and this is a part of that conversation. Anytime there's a shooting, the Aurora shooting, the Gabby Giffords, these people got guns. They got them legally. But here's the thing, is that these folks, how many times did we hear how many red flags about, well, this woman is giving guns to her young son? I mean, that's part of the conversation, is that as Americans, we need to be able to talk more openly about mental health and finding ways to stop things like this. We can't stop everything, you know, we can't stop things before they happen, but that's an important point, because people knew, people had issues, people had objections, and again, we're not mental health professionals, so we're not going to get into the discussion, but that's where the discussion has to start. Not on a type of firearm or a type of bullet, but the conversation has to be on how do we make sure people don't get these guns.
So you think there should be like a community vote that this person in our community is safe?
Well,
that one isn't?
and that's going to be that has to be part. Now that's not how it's going to happen, but how else do we do this? And that's the thing, is what would have stopped if we were to sit here today and go back in time and try to come up with laws? What laws could have been in effect that day that would have stopped that crime from happening? I can guarantee you that all of the laws currently exist on the books. It's illegal. It was illegal for him to have a handgun. It was illegal for him to have those guns at all. It was illegal for him to go onto a school property with a gun. It's illegal for you to shoot and kill somebody. There are all of these laws in place already. So what do we do? And that's where the conversation has to start. Not on, well, this type of gun looks scary and a civilian shouldn't have it. That is the wrong topic to focus on. We have to start talking about
Isn't
those
that the
things.
only one for what you just said?
On what's that?
That's the only one for what you just said, though.
The only...
You said there are a lot of the books that make all of those things illegal.
Alright.
So the only thing that would work is if the types of guns that would allow mass shootings not to be there.
Well,
I mean, from what you just said,
right.
the only thing would be not to have those guns available.
Well,
Not no guns,
but
but
in
those
the-
guns.
But the thing is that you could use any type of gun in a mass shooting, and that's the thing, is that if we're going to focus on an inanimate object of steel and not on a person's mental capacity, and that's what we're saying, is that you can't wave a magic wand and get rid of 400 million guns in the United States. It's not going to happen. A semi-automatic rifle fires exactly how a semi-automatic handgun fires. A revolver shoots the same way as a bolt action. They all, in the hands of the wrong person, can kill somebody. Any type of gun, no matter what type of gun it is, how big or small, in the hands of the wrong person can cause a problem. So what we're saying is that why are we focusing so much attention on types of guns when that same, just a few weeks ago, somebody used a knife to stab 21 children in another country. So what I'm saying is our focus should, the conversation should be on the background checks, the system itself, on the mental health situations and so forth, so.
A lot of people.
Okay, I'm sorry. I'll keep them
Oh, no,
shorter.
no, it's fine. I just know there are a lot of people with some questions.
Okay, so first, a brief correction on that. The same day of the Sandy Hook massacre, there was someone who had attacked people with a knife in China, but the key difference was that over 20 people were wounded, whereas at Sandy Hook, over 20 people were killed. Okay, so now to my question. I'm pretty interested in the whole concept of self-defense. And one thing I'm wondering is, where does one draw the line, especially with reference to standard ground laws and the Trayvon Martin incident last year?
You draw the line as far as how the law is set, or I guess I don't understand your question.
I believe, like, to what extent does can the right to self-defense be extended without going unpunished? Would
Right, okay.
standard ground
That's
be
okay.
a legitimate expansion of the whole doctrine of self-defense?
Right. Well, it starts with Castle Doctrine, which was the initial self-defense laws, and the Castle Doctrines are all state by state. That's in your home. The stand your ground extends to outside your home. And the only tenet you have there is any place you have a legal right to be, and you are essentially in imminent threat of great bodily harm or death. Now, there are certain situations where it's going to go to court, just like that particular case. While that law is in place, but there's so many elements to every criminal case. So we don't know all the facts. Nobody does. We don't know all the facts of, was there an imminent threat of great bodily harm or death, but that is the legal standard. That is the test of when are you able to defend yourself outside your home under the stand your ground laws. And that will be determined in a court, whether or not is it going to be applicable or not. But that is how the standard is set. So, is imminent threat of great bodily harm or death.
Live that.
Well, I guess what I want to say is, I have a number of things to say, but I guess the first thing I want to say is, when you were talking about how the opposition is emotional and reactionary, the difference for me is that the opposition, so folks, someone like me who's for gun control, I am emotional and reactionary, but we're emotional and reactionary for a change that is going to be for the common good and for the public safety. And I feel like the NRA is emotional and reactionary to the same degree, but for individual rights. So it becomes now this issue. So Second Amendment aside, if this is completely against the Second Amendment, we're not talking about that now. It's an argument against emotion versus logic and individual rights versus common good versus public health. And that's really, I think, the root of the issue.
Oh, I agree. I agree it's emotion versus logic. And so what I'm saying is that it's an emotional issue. I grew up in Detroit, Michigan. I know about gun violence. I grew up seeing it. I know. What I'm saying is that there's a lot of emotion. How is there not emotion to anybody who's been a victim of violent crime? But if we're going to talk about solutions that are actually going to work, that's where the logic comes in. So I'm for logic. I understand the emotional part. How could you not be emotional? But our bottom line is that I'm not going to start a debate talking about all the victims of violent crime when what I want to talk about is what's going to work, what's going to stop this from happening again. In application, I challenge anybody to tell me one example of where gun control has actually worked. One example. Because I can tell you 1,000 where it hasn't. The city of Chicago has the strictest gun laws in the country, and they've had over 500 murders. The places that have some of the strictest gun laws have, people are not able to defend themselves in very dangerous places. So I just want one example where gun control has actually worked. Well, and a lot of people like to compare other countries, but the reality is that to compare the United States to other countries, for example, my sister's a police officer in London. She doesn't have a gun. London has higher theft, robbery, rape, burglary than anywhere in the United States. In their rate, if you want to talk percentages versus rate, and we could certainly do that, but they have higher rates of murder and violent crime than we have more numbers. But again, their country is 1/10 of the size of ours, and their population is 1/4 of our size of ours. So it's very difficult to, a lot of people like to compare other countries without comparing populations and those sorts of things.
When you go to another country, you feel like you can walk around at night in the civilized countries and not be afraid, like you are in some of our major cities, because people walk around with guns.
Well, the bad guys are going to keep, that's exactly the point, is the bad guys are going to keep having guns no matter how many gun laws. They shouldn't. I agree with you.
I think
There
it's
are
at the manufacturing level, and I mean, hit it at every level.
Right.
With the background checks,
Right.
maybe
yeah.
quit making them so available to the general public. I think any law enforcement group would say that the general public should not be armed with military-style guns.
Actually, there was the police1.com just did a study that 90% of law enforcement doesn't believe in a gun ban whatsoever. My boyfriend's a federal police officer, but 90% of in fact, it's on their website. We actually work with sheriff's associations. We have a law enforcement division at NRA because they're the ones who help us try to figure out how do we actually get this to work. So we work very closely with the law enforcement. And you're right, it has to change. The bad guys are going to continue to have the guns, and we need to figure out what's the right way to go after them and not me, because I own a certain type. So
We're going to try to move back to the room. Go ahead. So.
Yeah, I'm from Chicago, and I definitely kind of, I'm well aware that gun control might not stop many gang members or other, people who have access to gun. I do wonder, and maybe you can tell me just, what is the NRA doing to fund programs that would stop that? I mean, you're saying that you have put together, blanking on the name, you did mention it, basically a program that would, excuse me, but put together a program that would, help to prepare, some sort of enforcement to stop it. But, for a city of Chicago, which has a ton of murders, it also has a terrible school system. And to say, we can put more officers into the school, I had 2 officers in my school. Did it make me safer? Maybe, maybe not. I can't know because I don't know if it deterred people or not. But I do know that the school needed $120,000 more to go to teaching and to go to school supplies. And what is the NRA doing to fund those programs? Because that's what I think is lacking.
right. Well, it's interesting because obviously we're the National Rifle Association. We aren't, an organization that gets involved in all these different issues. But I will say that we actually have we believe in crime control, not gun control. That's our bottom line. We believe in crime control because it works. We have a program called Project Exile, and again, I mentioned we have a law enforcement division, so we worked with our law enforcement division because they're better suited, and it's called Project Exile. It's a program that we actually lobbied to get money so that there would be, if you committed a crime with a firearm, there would be federal maximums on top of whatever crime you committed. No deals, no plea bargains, nothing, because most of the people that commit crimes with firearms are repeat offenders. And so we actually did do that, and we used it in Richmond, Virginia, that had the 3rd highest homicide rate in 1997. In a year, it was cut in a third. We went to Congress to lobby to get funds for the crime control model. President Bush actually incorporated our crime control model into Project Safe Neighborhoods during his administration. We wanted to take it to places like Chicago, Camden, New Jersey, Philadelphia, and we tried to lobby for the money. We weren't able to get it, but what's really good is that many cities, and we won't get credit for it, but many cities have adopted the model that we have about basically, if you commit a crime with a gun, there are federal minimums on top of whatever the crime is you committed, as well as no deals, no plea bargains, no parole, nothing if you commit a crime with a firearm. So we are happy to still see that residual effects of our program are still existing today. So that's a great question, because it's irresponsible to talk about how we think gun control doesn't work without talking about what we do, and those are things that we've seen that work. So
Moving back.
I'm still stuck on the 30 round thing. You were talking about having it on a handgun and then on your rifle that just is a regular rifle. But I mean, why does a person need the 30 rounds? I mean, if you're hunting and a deer, just getting 30 started.
well, most people use them for competition. I shoot competition as well, and the AR-15 is actually the most popular competition rifle in the country. The thing with the 30 round, and I know that they've really liked to go after that because it does sound overwhelming to people who don't shoot firearms. You would say, why would you need that? The reality is that people, again, often shoot for sport, for recreation and so forth, and in a self-defense situation, you don't know what you're going to necessarily need. But I guess our bottom line is, I understand why, I'm assuming you're not a shooter, and I understand why most people that aren't would say, I don't need a 30-round magazine. But I guess the problem is demystifying it. Is when you ask me why I need something, I guess I always take objection to someone asking if I need something, because I don't ask people why they need things in a society. But again, it shouldn't matter if you have 5 rounds, 10, 20, 30, 40, because if you ban 30-round magazines, most of these gunmen, these deranged killers, have multiple firearms. If you ban the 30 rounds and got rid of them altogether, I guarantee you that they're going to come with 2 10-round magazines or 3 10-round magazines. So.
They then have to carry 2 or 3 or 4.
And they often do, yeah.
And if you're in a competition, you just, that's regulated. That's get there and you get to have the 30 round only under those conditions.
Right. Well, and that's the prevailing argument on that side. And we just take objection saying, if you're a law-abiding citizen, our bottom line is, if you're a law-abiding citizen, it shouldn't really matter how many bullets you have. Why should the government say to you, you should only have 2, 5, 7? Because if we direct the question to a criminal, they're going to get them no matter what, even if they're illegal. Even if they're illegal, they're going to get them and so forth. But I certainly understand that that's the prevailing argument. So.
I'm going to briefly respond and then take
Sure.
your question. I mean, if you're a law-abiding citizen, though, you can't still just walk onto an airport without going through security. We still place restrictions upon law-abiding citizens. And I understand that it's a legitimate question to say, do we need, that saying, well, why do you need a 30-round magazine might be an inappropriate question. But when that's doubled with the idea that 30-round magazines cause greater harm than 20-round magazines or 10-round magazines, evidenced by what happened in Arizona with the person changing magazines being tackled and the violence ending, I mean, at that point you say, well, this is a reason why you shouldn't have it. What are the reasons why you do need it? And then you balance those against each other. And I tend to think that that's when you say, okay, well, you really don't need this and you really shouldn't have it either. Because you shouldn't have it and because you don't need it. That's the combining test to say that it ought to be regulated. Another way in the
people start working in politics, they're not going to understand.
way in the back.
That works.
Okay, well, both of you will get in. Whoever wants to.
So I see it's like kind of like towards the end. So I've been struggling trying to like find a way to like best ask this question without like with more tact. I mean, and I've always struggled with that. I remember like a week after Newtown, like I had this like friend on Facebook, and like I'd been friends with this person for like a long time since elementary school, and I knew like he was like You know, he was very pro-army. I mean, he was pro, like, you know, pro-gun, and I respected him for it. And so it was like the week after that, and then Wayne LaPierre had his speech about how the only thing that can stop a bad guy with a gun is a good guy with a gun, and sort of like saying that the bigger issue is like a culture of violence, I guess, as exemplified by Mortal Kombat and other video games from like 10 years ago. No offense. But then this friend of mine posted, I don't know if it was from the National Rifle Association's official Facebook page. It might have been like some like cheap knockoff or something. I have no idea. But it got me really mad, and I unfriended this guy. And what the picture said was, don't let Obama use the blood of innocents to propagate his own like ideas. And what I want to know is, why is that language okay to use?
I can assure you that that wasn't something that was on we wouldn't have ever put any image of anything like that on our Facebook. I know that there's a lot of folks that create a lot of things, and I understand that people can take this issue to far extremes, and they exist in both sides, and I understand that. It's unfortunate, but no, that was not something that was part of our official Facebook or anything. I know people like to use our logo and that sort of thing, but I can assure you that no, that was not something that was posted on our official Facebook site, and I understand your argument. So.
Way in the back.
Yeah, I was just going to say, I mean, mainly that I disagree. You keep making these assertions like, oh, you can pass this or this or this, and it just won't do anything. And I'm not saying that I agree. Like, I don't agree with banning necessarily like any specific gun or anything like that. But you say like, oh, well, if you ban that, well, criminals they're still going to get it, right? And I agree that if you like ban, you know, some type of gun today, tomorrow the situation would be no different. Criminals would still manage to get them. But over time, wouldn't this become harder to do? Because I mean, if criminals get these guns illegally and then they get caught by the police, then the guns can get taken away. And over time, it would take a long time, but over time, isn't it true that like the amount of this thing that you banned would certainly like decrease, and it would be harder for criminals to get that and use that?
Right, yeah, no, I mean, if you ban anything, it will become uncommon over time. Absolutely, yeah. And that's true. I guess our assertion is that we just don't believe that we should deprive the law-abiding folks from having something and be blamed because of the criminals that do bad things with guns, that the other law-abiding citizens should be deprived of a certain type of firearm they might want to use. But yes, at the end of the day, yes, if we did wave a magic wand and got rid of certain types of guns, they would, of course, decrease in society.
I don't think that you meant magic wand. I think that you meant an act of
or
Congress
over time.
to
Either
ban
way.
it
No, I'm not
over
minimizing
time.
what you say. I'm saying you're right. Absolutely. Either way. That yes, if you ban something over time, it would of course have to be less of. But we just object to that notion in general, just because if there are more good people out there that are law-abiding that want access to that, being punished because of the works of a criminal or a madman. So.
Other questions?
First of all, I just think it's, I do support guns, and I do support the NRA's mission. I think that they've made some big blunders in how they've dealt with stuff, but one of the big issues is that people kind of see the NRA as like this corporate lobby group, which I think that, there are corporate lobby groups, but if you look at it, the American Brewers Association pays more money each year than the NRA does, and I'm fine with that. My dad's a craft brewer, so that's perfectly great.
Right.
But I think that the big thing with the NRA is not actually that it's coming from the gun manufacturers, that it's the people are so vehement about it.
Right.
And if the people are so vehement about it, is the situation, I guess this is to both of you, how do you approach the people, like the constituents? How do you deal with them rather than just trying to go through the back channels of Congress, rather than just trying to create legislation? Because obviously if something as horrible and traumatic as the Newtown massacre is going to, is not going to, that changed, some people have moderate opinions, and then that changed their opinions. They said we should have fewer guns. But if stuff like that isn't going to change their opinions, how do you really do it? And I guess I want to know, both of you will be honest, realistically, because before this past year when we had this kind of spurt of violence, a lot of people seem to think, and I could kind of believe it, that the gun debate was largely over. That people, that the pro-regulation side had kind of given up, and now there's obviously more ammunition, so to speak, to go into it. But like, realistically, do you think there's a solution in the next 10 years, or do you think it's going to be the same way in 20 years?
Well, it's changed. The debate has changed forever, absolutely, after this. You're very right in saying that there's a very big misconception about NRA. We're powerful not because we have lots of lobbyists and money. We're powerful because we have 5 million members and 100 million gun owners. We only have 6 federal lobbyists. I know they make it sound like we're this really powerful with armies of lobbyists and money. My salary is paid by donation only because that's what the law says. We only have 6 federal lobbyists. We aren't this big, scary, as they're saying, oh, you're powerful, you can do whatever you want. That's not true. The reason why we're powerful is because we have very passionate, educated members. And the reason we stop things is because of them. Not because of me, it's because of them. So the debate is going to change, but the people that are going to have the debate is not me. It's not going to be our 6 lobbyists. It's going to be the gun owners. And they've already proven that point because that happened just 2 weeks ago. So the debate's going to change, but in all honesty, it's not because the NRA building is powerful. I think this gentleman especially is confused about the power that we yield as an organization. We yield power because people, we're powerful. Again, we have 6, like I said, we have 6 federal lobbyists. We're a nonprofit. My salary is paid by donation only. I can't use a penny of membership money to do what I do. It's illegal through the IRS. So the debate is going to be between the people. It's going to be between both sides of this. And they've come out, and it's good. It's good because they have to have these debates because, like you said, the debate wasn't as intense or passionate as now, and it's going to be on both sides.
And I disagree with what she said. I mean, there were laws that were supported by approximately 90% of Americans that failed. This is not a debate that's up to the people, and that's very problematic. When you have public opinion that says overwhelmingly in favor of one side, I think that it's clear that there are special interests, and I can't pinpoint a direct dollar that affected that, but I think it's fair to say that a lot of that money comes from the National Rifle Association funding different political campaigns and different lobbying aims to the end that I really can't agree with the statement that this is a decision that's left to the public. I mean, sure, we could overwhelmingly diselect someone, but that it's not an issue that people care enough about to do that, even though 90% of Americans were in favor of particular bans that were, or particular regulations that failed. But if there was a question there, then...
Well, it's really, the thing, there's a lot of discrepancies in what you're saying, and I feel a little bit confused. When you say, the gentleman in the back, when you were saying that it's a really complex issue and there are all these other things that we need to be discussing, not just the kind of guns. The thing is that the NRA does not deliver that kind of message. They're consistently delivering this message that the individual right is paramount. That's what they're delivering. Individual right, Second Amendment, all of these things, and it's in my personal opinion to the detriment of public safety and the common good. That's my personal opinion. But when you say it's all of these, it's this huge complex issue, absolutely it is, and there's a number of different solutions. One of them, some of them being the mental health issue, the mental health component, all of those things. I also believe that one of the issues is also the types of guns that are on the streets. But I'm confused as to why the NRA does not discuss the broader issues and embrace, like he's saying, the public's opinion and the debate that everyone is having. The NRA is really focused on this one particular issue.
Well, we try our best to get the broader spectrum. You can only imagine that our ability to get to the general public is limited. We don't get to do as much as we'd like as we don't get the opportunity. But for example, he mentioned the 90%. The 90%, just to be very clear, is the question that was asked was, do you believe people should go through background checks to purchase guns? Yes, 90% of the public agrees for that. And the reality is that there's a system in place for background checks, and we are the ones trying to improve it. So it depends on how you ask the question. So when you ask the question, do you believe that people should be subject to background checks in purchasing guns? Most people are yes, and we say yes too, because we're the ones who created the system. That's not what that legislation was about. So, but you're right, the message is difficult for us to get out. We have to get it out in a broader way. We do try our best, but you're right, and that is proof to me that, you know, that was your perception of our message, and that tells me something, that we're not getting the broader message out there, if that's all you've heard, because I can tell you that the broad message we're trying to get out there is broader than it's ever been. Oh, goodness. So no, I would agree that, yes, the message should be out there better, and shouldn't be inclusive to all the things we're trying to say. And like I said, that shows me something, that if that's the only message you're getting from us, then we have to do a better job to make sure people understand that this is a robust issue, which we can play a part in. We can get the appropriations. We're good at getting appropriations money for things. The money that we're only allowed to get. We can't create a tax. It's unconstitutional. But we can get appropriations for the mental health checks, for things, and that's what we're going to focus on. Again, it's unconstitutional for us to ask for a tax, but our only method is through appropriations. But people don't know that, obviously, and that helps me let people know that we have to get that out there better. So, did you have another part of? I didn't know if you had another part of a question, but okay.
At least one of the very last questions in the back.
Okay, so, you know, you said earlier that, you know, the right to bear arms is where your tie-in to self-defense comes in, right? You know, the fact that the majority of self-defense happens in terms of our ability to own firearms and whatnot. So, why not, instead of having this, you know, current wording of the Second Amendment, which says about a low-regular militia, why not center the debate and contextualize debate around self-defense and amend the Constitution, like was suggested earlier, to try and include self-defense as a central argument, so we can, you know, evaluate that better, and maybe emulate other countries like Australia and England that have been able to create comprehensive gun reform that has been successful. Sure, they're not, you know, exactly similar to America, but we can tailor it to fit our country better. And so why not make that necessary amendment so that we can contextualize the debate in a better format and try and get more, like, you know, direct response?
Well, the reason why is we don't need to amend the Second Amendment to contextualize the debate at all. We can leave it as is and still have a debate about what's going to work. That's the whole point, is that you can change whatever words you want about the Second Amendment but if you're trying to contextualize a debate, which is the term that keeps coming up, well, let's just contextualize it then. Why do we have to amend the wording of the Bill of Rights? The beauty of this is it's a timeless protection of individual rights. We can contextualize it any way we want, which we're doing already today. And so that's I guess the point I was trying to make, is that this is a great debate to be had. It really is, and there's a lot of parts to it. But we don't have to reword or, you know, change words to have the debate. You know, you mentioned other countries. England, but we can look to Canada, who spent billions of dollars on a gun registry program over the course of the last 10 years, and we just saw the chief of the mounted police come out and say it hasn't helped them solve a single murder. So we do look around to see what what works, but they also don't have a Bill of Rights and a Constitution, which, you know, is interesting as well. So it makes us obviously even further different. So.
Well, I was going to say that, first of all, you're right. You know, like, we can contextualize debate however we want, but more often than not, you know, people can use the Second Amendment as a cop-out argument to try and change the argument of debate.
Right.
Additionally, when we're talking about, you know, what models we follow, like, sure, Canada might not have been, I'm not even sure as to the efficacy of the Canadian gun reform, but in terms of Australia, they had a Bill of Rights, and they were, you know, very similar to us. And so why not look at the examples that have been successful and try and emulate that, as opposed to look at those that have been failures and try and use that as an argument to not go?
Well, the bottom line is that correlation is not causation. There are many countries that have very strict gun control laws that have very low murder and violent crime. There are a lot of countries, probably more so, that have very strict gun control laws that have high violent crime. So it's difficult to do that. I understand why people do that, because it seems a little more convenient, but the bottom line is we're very unique, and it's so difficult. Again, I could bring up lots of examples where gun control has worked in other countries and it's not worked in other countries. It hasn't worked here. That's the thing, is it hasn't worked in the United States. For example, you know, I could do that all night, but Washington, D.C. had a handgun ban since 1976. No handguns whatsoever. You couldn't have an operable long gun in your home for anything. And their violent murder rates and crime rates, they were the murder capital of the country for 30 plus years, but that should have been the crown jewel of safety. That should have been the safest place on earth if nobody was allowed to have an operable firearm. It didn't work. It doesn't work in Chicago. It doesn't work. I'm just saying that correlation is not causation. I'm not saying because there's a ton of guns that there's going to be less crime. That's not what I'm saying. I'm just saying you can't tell me if there's more guns, there's going to be more crime, because in actuality, in our country, it's been more guns, less crime. So.
Well, I mean, the United States is unique also in that it has among the highest crime rates and among the weakest gun laws in the entire world. If you look
crime
towards DC,
numbers, not rates.
Sure. Crime
well, that's a big difference.
But we also have
crime
among the
rate.
highest crime rates. If you look towards what happened in DC, I mean, it's difficult to say that we have a law that bans handgun purchases in DC, but then you can buy them in Virginia and Maryland. I mean, I'd just say that that's
right, yeah.
That's a policy failure, because if you can buy them 6 miles away,
which is illegal to do. But what do you do then? That's what I'm saying.
Well, I'm saying that it needs to be.
Create another law that no one's going to follow.
It would need to be more comprehensive. I mean, we're literally talking about driving 6 miles than to buy a gun. So, I guess my point is though that the Supreme Court justices in their in their dissents to Heller with regard to the DC law said, look, the Heller and his fellow amicus brief filers, such as the NRA, are saying that crime is still high in DC, but the NRA, as you said, never does a study. Well, it never commissions a study.
The FBI does it for you.
What we need to know is whether the situation was better or worse, not whether it was good, not whether it was bad relative to the rest of the country, but whether it was better or worse than it otherwise would have been.
Well, you can actually look these numbers up. FBI.gov actually categorizes all of this. The crime rate after the gun ban went into effect, violent crime went up 300%.
But you just said correlation does not imply causation. I mean, we pass a gun law.
I'm talking about gun ownership. I'm not saying that more guns is going to equal more crime, whereas actually more guns is equal less crime. I'm not saying because. Now, murder and violent crime, this information is everywhere. In fact, since 1990, I know all these things in my head because I have to say them all the time, but since 1991, there was a spike in violent crime. There are more guns in our country that have gone up over 10 million every year since 1991, and the violent crime rates have dropped 48%, and the current murder rate is down 52% as the number of guns goes up. That's where the correlation. I'm not saying because there's more guns that the violent crime rate has gone down 48% and murder 52%.
Right.
I'm just saying that you can't tell me that if there's going to be more guns, there's going to be more crime.
Well,
Washington, D.C. but all of this, we don't do these studies because the FBI does them. FBI.gov, it's fantastic. In fact, the murder rate's gone down even further in the first half when they just published the first half of 2012. But what I'm saying is that there's no instance of these gun control measures that it's the same debate. They keep talking about the same gun control measures that are never working. So they need to talk about things that might work, and that's all we're trying to focus on.
Just to briefly respond then to move to the last two questions, I think that what DC really gets away from what we're talking about is that DC was talking strictly about, not strictly, but talking about a provision that included banning handguns.
No, they were completely, no, in 1976, no. In 1976, the D.C. City Council banned all handguns.
Right, I know
entirely.
That's what I'm saying, and I think at least I have.
But people were still being murdered by handguns. But they said no handguns whatsoever in 1976.
Right. And I understand that cuts at self-defense capabilities, which is something that I've kind of given a disclaimer rather abundantly clearly against, is that I don't want to cut at basic self-defense capabilities. I understand that many people in this room might have a more liberal view on that than I do, but I haven't advocated taking away
And I didn't say you have. I'm just saying that the gun control measures that they've tried have failed. Because if you weren't able to have a handgun, if they were all banned, and you couldn't have an operable long gun in your home, it had to be unloaded, disassembled, locked with the ammunition separate was the law. So I'm saying if you can't have an operable firearm in Washington, D.C., that should have been the crown jewel of safety in the country. Nobody, if the laws worked, but that's what I'm trying to say is that they keep proposing the same things that haven't worked. We're trying to get the debate to go in a different direction so that possibly we can find solutions that actually work.
I really understand the black market logic of this failing. If all you have to do is drive to Virginia or Maryland, and
But
buy
you
a
can
gun.
drive
I
any
mean,
state. I could drive from Texas. I mean,
yes,
in
I mean
Maryland, you could
it
drive
would
to
have to be
US,
comprehensive. I mean,
Right, but it's illegal. So what else do you do? It's illegal for
But-
you to
but my
drive
point
to
is-
Virginia and
my-
Maryland to buy a gun. So what then? What's
but
the
it,
next law?
but
that
my
you would
point is, it
propose?
can't be that law doesn't necessarily work because
Well,
it's
what law
still
would
easy.
work?
I mean, I'm not
I'm not a professional. I'm not an expert. But what law do you think?
I
just
haven't
in theory
suggested
would
I
work?
haven't suggested a handgun ban, but I think,
But what
as
law
I've said
would work?
repeatedly, bans on weapons that are not optimized for self-defense across the nation, not across D.C., not across an area that has a border right next to it. That
What
you can.
state doesn't have a border right next to it?
Nobody means the law.
I think he means you can't go to that state, you can't cross the
Easily.
bridge.
But the same thing goes. What I'm
I
saying is
I
that
meant
what
the
laws-
U.S.
I just want someone
meant
to
the-
tell
I meant
me
the
what
United
laws
States.
would work.
I meant a federal law.
I just mean what federal law, what any law would have.
A ban on or otherwise duly appropriate regulation on weapons that are not optimized for self-defense.
Well, how is it optimized for self-defense?
That's determined via public opinion, industry experts, and
I'm gonna go in circles. All right, so
all right,
let's do the last.
all right.
question.
Last two questions. Yeah, go ahead.
I have a question for both of you, but I want to ask you first. There was a weapons ban of sorts that was a federal ban that was in place that expired a few years
Federal
ago.
assault weapons ban.
Pardon?
Federal assault weapons ban.
Right. What was the effect of that ban, crime rate before it went into effect? What happened once it was in effect, and what happened after the ban?
I mean, there's going to be an issue here, which is we're going
Well,
about
there's
to say
Department of Justice study, it's
completely
facts.
different statistics.
But it's the same exact study, so.
I mean, a lot of things went down that were kind of unintended effects, such as the arms trafficking to drug cartels in Mexico, since that's their weapon, since semi-automatic weapons that were banned those assault weapons are typically the weapon of choice there. But in the U.S., I mean, crimes perpetrated with automatic weapons, or with the assault weapons that were banned, significantly went down. Now, granted, you could buy other firearms to perpetrate a crime with, and she's going to say that the overall crime rates were relatively consistent, but crimes perpetrated with those weapons went down, which says credence to the overall theory that she said earlier, which is that you pass a ban, and over time, the appearance of that weapon goes down.
That's 100% false, and there's a Department of Justice study. Anytime there was a gun ban from 1994 to 2004 that banned the so-called assault weapons, it sunsetted, and nobody looked back because it didn't have an effect. And the problem is that the reason why there was no anti-crime benefit to the assault weapon ban that we had for 10 years is that nobody was using those guns in violent crimes and murders. Now, the Department of Justice is compelled to do a study, and they had to do one. It's public knowledge. You can all read it. Now, whether you want to pull one sentence out of it or read it for the whole is what I challenge you to do. But when you read it as a whole, the entire Department of Justice study that was done, compelled by the Clinton administration, you will find that the guns being used that were banned were involved in 0.7% of the crimes. Therefore, the ban didn't have a chance to be successful. It didn't have a chance to have an anti-crime benefit. So I do say that I understand that people can pick and choose anything they like out of an opinion, out of a study, but I would say when you read it in its entirety, you will find, and I have, you will find that the gun ban didn't work, and the reason it wasn't re-upped was that every single person in Congress knew that it didn't do anything, and it sunsetted without a single vote on it again. So again, you can read, again, just like you can the FBI crime statistics, the Department of Justice statistics, all of these things are public knowledge, and I'd certainly, don't take the NRA's word for it. Everything I've said tonight, don't take my word for it. You can find all of these things on your own in FBI stats, in reading the Federalist Papers, and reading everything I've said, reading the Heller decision, reading the McDonald decision. These aren't the NRA made-up views of things. So.
Well, I guess my thing is, first, like, there are problems with the statistics. That's kind of one of the things with the gun control data is, like, each side comes out with statistics that are proven to be right, but, like, they don't necessarily correlate. Like, I mean, England has less crime than we do, and they don't have guns. Then on the other hand, you don't have as many guns. On the other hand, Switzerland is, like, incredibly gun heavy, and they have less crime than England.
Right.
You know, and, like, in Boston for a long time, people were complaining that the gun control wasn't working there because there was, still all this crime, but it turned out that part of that might have been the fact that Whitey Bulger's brother was the district attorney, some of it, it's not all, but my question is about, the mental health, and, I understand the NRA is the National Rifle Association. It's not the American government. It focuses on one specific issue, mostly. And, I respect that, and I understand that when something as horrible as, a mass shooting occurs in something like Sandy Hook, the NRA has to go a bit on the defensive, because obviously the NRA doesn't want, it's not like they want this kind of stuff to happen, but they do have to defend their views. But, one thing that I kind of noticed is, this whole thing about mental health, kind of just this term getting thrown around is oh, that's the alternative. Because if you're going to be against gun control, then you have to be really for mental health. I mean, what exactly does that entail, and how much, and I think actually the guy was getting at that before, how much individual liberty does that does that entail? Because I mean, one of the Columbine shooters, there's a German rock band that was criticized because one of the Columbine shooters liked a song of theirs, and I like that same song. I haven't shot anybody yet, and I don't intend to. I mean, so at what point do you get overprotective, and just is mental health, is really just throwing around the term mental health going to do anything?
Well, the reason why that's become a pinnacle point is that there have been mass shootings, and the common thread between that is that each of these people was mentally ill. Some adjudicated, some not, but everybody at the end of the day knew. And so we've tried gun bans. We've tried banning certain types of guns. Some states still have assault weapon bans, and terrible things happen there. We have gun-free school zones or gun-free zones. Terrible things happen in gun-free zones. We've tried a lot of different things, and none of them have stopped these things from happening. So our bottom line was that this is the common thread. So instead of declaring that this is a gun-free zone, you can't have a gun here, knowing that a criminal or somebody with a criminal mind isn't going to stop because, oh, it's a gun-free zone, or you can't have this gun. Well, none of that was working. But the common thread was the mental health issue, and that's why I think it finally, and deservedly so, has become, it's certainly not an alternative, it's just become the pinnacle point of the conversation. But you're right, it's going to be a very complex thing, and I don't know where that's going to go, but we know that has to be the starting point. And the only ability we have in that debate is to lobby for the money for the mental health records to get into the NICS system, and that's where our role is.
Yeah, and I think that what was brought up earlier is a very legitimate point, which is that the NRA, if they're going to claim, no, the solution is not gun regulations, what you're telling us is wrong, here's the alternative, and they need to actually legitimize that. And if she says they can lobby that, if she says that they have the power to do that, if she says that they can present testimony to Congress, that they can present interest to Congress, I really do agree with what the gentleman said earlier, which was that they need to do that it's an incomplete argument not to do that. And we hear her saying that they have done that. I'm not familiar with a significant body of evidence of them saying that they actually have constructive programs that would cost money, which obviously is unpopular with their base. I'm not familiar with them promoting those pieces of legislation and talking about them in the media. If they do, I think that's great, because I think that's a necessary add-on to finish their argument.
The NICS, the National Instant Checks Act is what we worked. In fact, Carolyn McCarthy is one of the most anti-gun congresswomen out there. We actually worked with her to get the money. So when it comes to money issues, which I was trying to explain about appropriations, is that it doesn't matter, party lines don't matter. We worked with some of the most anti-gun Democrats to get the appropriations money so that we could improve the NICS system. So the National Instant Checks and Improvement Act is a perfect example that you could look up to see where we got a lot of pushback, even from some of our own members, about working with these folks that they saw as anti-gun. But the money issues are very different than the actual substantive legislative issues, and we'll continue to work across lines to get the money for that. So that's one example you could look at.
All right, I guess there's I presume this is the last one.
Just one more question. So when Jake brought up Columbine, I remember the fact that was mentioned about. I remember that on campus there as thin.
Right.
You know.
Well, that's exactly the point of having, because we didn't have a program to train, so that's part of the reason about having very specific training for those types of situations, and we feel that we could be some benefit to providing that training with our folks. So you're right. I don't know who that person was or what type of training they had, but that's why we believe in a very specific course of training for schools, for everybody involved in a school situation. So we hope that that's going to be a situation, if there is an armed officer or resource officer in the school, we can provide very specific training for them.
Okay, I brought that point up earlier. I believe I actually might have misspoken and tied it to Sandy Hook, and I entirely meant Columbine. I get your point, and then that's where you say, well, I really hope that they don't have a 30-round magazine, so that the quicker the police officer gets there, the fewer the people have been shot. And I hope that their gun shoots slower, and I hope that their gun can't kill as many people, because if the police officer is understandably using the restroom or is off on some other wing of the school and it takes him 2 whole minutes to get there, hopefully in that time the regulations that we've put in place have minimized the damage in the time that it took the police officer to get there. All right. Thanks so much for coming out and for staying to the end.